On this week's episode, we answer members' questions about the Supreme Court, the ATF, and the new federal gun law.
I made the devil run. I gave him poison just for fun. I had one.
All right. Welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and pick up a membership today if you want to get exclusive access to hundreds of pieces of analysis and exclusive stories that you won't find anywhere else in the world. You'll also have the opportunity to submit questions for our special Q&A episodes like this one. I'm joined by contributing writer Jake Fogleman today, and we're going to try to answer some of the questions that our members sent in. And if you want to send in questions the next time we do one of these, make sure you head over to the site and check out our membership options. But we got a lot of good questions, right, Jake? We were just going over some of them.
I would say it's impressive how many good questions we got in a short span of time. So good membership, good engaged membership.
Yeah, I've always been impressed by the questions our members ask. They're clearly very knowledgeable about what's going on in the gun world. And so they make our jobs easier because they ask questions that are relevant and we can hopefully actually provide some answers to. So that's what we're going to be doing today. Obviously, there's been a ton of gun news over this last couple of weeks here. You had the Supreme Court hand down its first major gun decision in over a decade in New York State Rifle and Pistol Association v. Bruen. And that's going to have monumental effects on gun laws throughout the country, not just gun carry laws, which were at issue in the case, but also really all kinds of gun laws, especially your more modern regulations, things like assault weapons bans or magazine limits or handgun rosters, different kinds of licensing schemes. They could all be affected by this. So we got a lot of questions on that. And then also, of course, you had the federal government pass its first gun restrictions in literally decades, restrictions on who could own guns. So we got some questions on that as well. And the ATF has, of course, been up to a lot over the last weeks and months. So we got all kinds of interesting questions. But let's start here at the top with a question from Bill Crisafulli. Sorry if I pronounce anyone's names wrong. I apologize. And I feel your pain as Stephen Gutowski. That's not an easy one either. But here's the question. In a recent email from the Second Amendment Foundation, I read the following passage, but I'm not sure I understand what it means. This is a quote from Alan Gottlieb, who's the founder of the Second Amendment Foundation. They're very active in the gun rights litigation throughout the country. And he said, "It is also important that the High Court granted all writs of certiorari in these Second Amendment cases as they were being remanded back for further review. That tells me we have a Supreme Court willing to rein in lower court activism and limit how far they will allow local and state governments to reach when it comes to placing burdens on the exercise of a fundamental constitutionally enumerated right to keep and bear arms." So what's Alan talking about here? He's talking about these recent GVRs, as you called them in a piece, right? Right, Jake?
That's right. Yeah. So while Bruen was being, it was argued and then we were waiting for a decision, there were also other gun cases pending Supreme Court review that were stayed because obviously with a decision as monumental as what happened in Bruen, it can affect future gun cases. So what the Supreme Court did a week after Bruen was decided is they did what's called a grant, vacate, and remand order, or GVR, as you mentioned. So basically what that means is the Supreme Court grants cert or certiorari just so that they can vacate the previous ruling from the lower court and then remand, which means they send it back to that lower court to review it under the new standard based on what happened in the Bruen case, essentially. So what the Supreme Court did is it kicked these 4 cases back to the courts where they came from and said, hey, you need to relitigate these because we have a new standard for reviewing Second Amendment cases.
And I guess one of the important things to note about that is all 4 of those cases, the gun regulation had been upheld by that lower court, right?
That's right. No, that's right. Yeah, there was a case out of the Ninth Circuit where they completely banned the concept of carry outside the home, which obviously is Young versus Hawaii. Yeah. It's severely called into question by the Bruen decision. So I think we all know where that's going to go. There was the assault weapons ban case out of Maryland, Bianchi v. Frosch, I believe that one is. And, you know, as you pointed out, assault weapons bans are a relatively modern invention. And when the Supreme Court creates a new standard that says you need to look to the history of the Second Amendment when it was ratified, that also calls that into question, depending on how things go at the court. And then there were two mag ban cases, one out of California and one out of New Jersey. So a similar story there with the assault weapons case.
And magazine confiscation cases, really, because those cases, you wouldn't be allowed to keep the ones you already own. But yeah, so that's extremely significant because it shows you the potential reach of this new ruling. It's not just limited to gun carry, even though that's the immediate impact of it.
Right.
You know, that was the immediate question at hand in Bruen, was whether or not New York's gun carry regulations were too restrictive. And my air conditioner is turning on right now, of course. But I don't know if people can hear that. They're always paranoid, of course, when you're doing a podcast about what sounds are being picked up by the mic. But anyway, hopefully you can. But regardless, the New York law was viewed as unconstitutional by the court. It violated the Second Amendment by way of the 14th Amendment, because that's how they incorporated the Second Amendment protections to the states. You know, the federal Constitution restricts the federal government, but since the 14th Amendment was passed, those protections have now been over time extended to the states. But the problem was with the New York states, the way that they subjectively judged whether or not somebody was qualified to have a permit was ultimately what doomed that law. But clearly here by GVR and these four other cases that aren't all gun carry cases, it shows that this new standard they set in this ruling that you discussed briefly there is going to have an impact well beyond gun carry. So that's what Alan Gottlieb's talking about. He's, you know, that's a way of also basically telling the lower court that you got it wrong. Right. GVR, you know, granting a case, then vacating the lower court's ruling, and then sending it back to them to say, hey, do this again is a way of telling them they're wrong. Right. Without going into the full on, you know, hearings and oral arguments and writing, you know, opinions on them. So that's what Gottlieb is talking about there. All right, next question here. This one's from Joseph Francella, who asks, what does this mean for people in possession of magazines that hold more than 10 rounds currently? I know that in California, the ban on new sales and imports is in place, but there was a stay placed on confiscation until SCOTUS took action. So he's talking about, that's Duncan, right? I believe, out of California, that case. So yeah, what do you see happening now? Yeah. So like you said, he's talking about Duncan v. Bonta. We covered it a couple times on the Reload in some news stories, but that was one of the cases that was just GVR'd back to the Ninth Circuit. And as he pointed out, they did, California updated its magazine law to completely ban the possession of magazines that were previously grandfathered under their ban. So what that essentially means is you now have something that's criminal contraband and you have to turn it in. So confiscation. But what they said was, hey, the Supreme Court's reviewing a gun case. This could change the way we look at Second Amendment jurisprudence. So until that goes through, we're not going to make you turn in your magazines. Well, now that it's been granted and obviously there's live action happening in the case, I see this stay, you know, still holding true. Yeah. Because they're obviously dealing with the ramifications of the new standard in Bruen. So this is a live question now. Right. And it'll be interesting to see how the lower court feels this one out. You know, what they do in response to Bruen is one of the big questions. And I think we have some questions on that later on. So we'll get a little more into it then. But I think it's one thing's important to note is nothing changes immediately. Right. This will probably take months for these cases to be relitigated. If not years. This new standard. Yeah, maybe years. You know, for these ones that have been GVR'd, I would expect those to move a little faster. Some of these other laws that might be called into question, like, handgun purchase permit
Sure.
schemes in some states that are that ride the line between shall issue and may issue, right? That ride that line between, giving the government official ultimate say over who gets to buy a gun. Those are probably imperiled by this, but we'll have to see. That'll probably take longer for a ruling to make its way through.
Yeah.
Or for a new case to make its way through, even with this new standard. So, but these GVR cases, those will probably be, maybe not weeks, but months, I would think.
Yeah.
So that's what you're going to see with that bag ban case in California. It's going to go back. They're going to, the stay is going to remain. They're not going to start confiscating magazines. I don't believe. But yeah, it'll be a while before that gets fully fleshed out. All right. You want to read the next one?
Sure. Yeah. This one comes
It's
from
a little bit of a long one, but you can just get to the gist of it, I guess.
Sure. This comes from Ken Beaulieu. Sorry, once again, apologies, Stan, for the name butchering.
We have people with a lot of interesting names who are members. He's asking about Ken is asking about carry on military bases, right? We don't need to get into some of the details. I don't know if he wants them identified, but he's asking basically about concealed carry on military bases. This is something that's been controversial over the years, especially since you've seen a number of terror attacks on military bases. They generally have bans on concealed carry, unless you're on some sort of duty that requires you to have a weapon. And so so what's the gist that he's getting at here?
Yeah, he basically wants to know how that current prohibition of carry on military installations can interact with the sensitive places doctrine that the court kind of touched on but didn't really fully flesh out in the Bruen decision. So he just wants to know if there's a path forward for someone like him with a permit to potentially carry on his military installation, which is an interesting question, I think.
It is. And he throws in here, so he touches on what's going to be a very big point of contention going forward now that, may issue is no longer constitutional. What you're probably going to see the most fights over are these sensitive places exceptions, where you can have gun-free zones effective. Because the court has said repeatedly, said it in Heller, it said it again in Bruen, and Roberts and Kavanaugh emphasized it in a concurrence that, the Second Amendment is not an unlimited right, I believe is the exact term that Heller used. And there are restrictions that can be placed on it. And one of those that they've specifically mentioned is sensitive places. So, what does that mean? What is a sensitive place? I mean, right now what you're seeing in New York with their attempt to respond to Bruen is basically they're trying to make a lot of place. They're trying to really expand, really push the limits of what a sensitive place exception can be. In fact, they're even doing, they're sort of flipping private property exceptions on their head from how everyone else has done them forever, which is to say that private property is de facto off limits unless the property owner explicitly posts a sign to say that it's legal, that they allow gun carry there. So there's going to be a lot of test of this, and military bases will be an interesting one. Ken says, to me, sensitive places include courthouses, secure airport terminals, inpatient mental health hospitals, and perhaps most places where magnetometers are in use. But I don't think all government buildings qualified as a sensitive space. I think that's probably a common view. Like the more reasonable view of what a sensitive place is, something that has security for it, usually, a courthouse, a school.
I was going to say that's what kind of calls into question perhaps how the courts will view military installations, because there are MPs stationed on military installations that are obviously armed. I could definitely see a court saying, hey, sorry, you don't need to carry. There's armed people there for the purpose of security. So
yeah, honestly, it'll probably come down to the judge.
Probably,
which,
yeah.
frankly, we're going to get into this in just a moment. I think the next question deals with this. I think, frankly, that's the answer to a lot of these questions. It's kind of going to come down to the judge, and it's going to come down to how strongly the Supreme Court feels about what the lower courts are doing. You see in Bruen that they're very angry about how the courts had been handling Second Amendment cases over the last decade or last 12 years since McDonald. But they didn't, they didn't. One of the big criticisms from the gun rights people is that they hadn't done anything about it. And so, if the lower courts kind of try to work around what the Supreme Court has just put down, in this case, they're going to have to the Supreme Court's going to have to actually take up more cases to make sure that they're keeping them in line, basically. Because I think it could go either way. Military bases, are they sensitive places? You could certainly make an argument for they are, and you can make an argument for they're not. I mean, military bases are kind of like, in a lot of cases, are kind of like whole towns, right? And so, can you make basically an entire town a sensitive place? Well, it is inside a military base. That's fairly sensitive,
right?
But I don't know. It's
an interesting legal question for sure. Yeah. I just don't see. I just don't know if I see courts telling military installations what they can and can't do. That's another, I think, wrinkle in this that judges may be hesitant to get in those affairs.
Yeah, you may be right. I think Charles Cook was, on our last podcast, he was talking about how he expects the Supreme Court to really, or I guess he was saying, advocating that they shouldn't necessarily get involved in micromanaging these things, and they should just focus on big picture questions. And so this might be too far down the list of should the federal courts be telling the military whether or not their installations are sensitive places where they can ban guns?
Right.
Yeah. I don't know. I mean, I just be honest, but obviously the counterpoint to that is these attacks we've seen on these military installations. And you're talking about keeping trained soldiers from being able to carry their firearms to protect themselves.
That's a good point.
It's not an easy thing. I do lean towards your view though on it. And so we'll have to see, honestly. I mean, that's another one where you're probably talking about years rather than months in terms of a case like that shaking out. I'm not aware of one currently. And so you'd have to see, you'd have to be, there's also a lot that comes with being in the military as far as how your individual rights are affected during your time in the military while on a military installation, right? There's probably, I would imagine there's case law that deals with that as well.
Sure.
That would come into play here. Yes, you have Second Amendment rights, just like you have First Amendment rights, but I don't know, if you're on an aircraft carrier on duty and you want to refuse to do your work because you're protesting something,
right?
I don't know if you could win a First Amendment case on that.
Or you're barred from tweeting your sensitive location when you're out on deployment or something like that. That's a curtailment of your First Amendment rights. There's all kinds of things that come into play there. Anyway, sure.
It's a good question. Next question here. Yes, very good question. There's a lot of like we said at the top of this. There's a lot of really good questions. It's going to be an interesting debate, I think, moving forward. But the next question, kind of as I alluded to, gets into part of what we were talking about here, and this one's from John Lopalato. All right.
Sounds right to me.
We are, we've got some very, very unique names among our membership, which, hey, like I said, I got crazy Polish names. So maybe that's why we're attracting other people with fascinating ethnic last names. But regardless, John says, he says a lot here, but I'm going to try to condense it down a little bit. He's talking about Thomas being frustrated with the lower courts after Howell McDonald, which, yes, that definitely comes across in this ruling. And he's saying that effectively, he was saying in most jurisdictions, especially the Ninth Circuit, effectively became a rational basis test where just about any gun control legislation that was put forward by legislators was upheld. This is a common critique, right, that you've seen of federal litigation on guns over the last decade. And this is one of the reasons why gun rights, this is why Thomas kept referring to the right as a second class right. The idea was that especially in the Ninth Circuit, I don't believe they ever struck down any of the gun regulations in California or in the entire circuit. So
not to date.
They had this two-step process a lot of lower courts were using that Thomas said was one step too far, which basically the first step was to identify whether or not the Second Amendment rights were implicated in by the law. And then the second step was to use a balancing test to determine whether or not the state had, usually they would use intermediate scrutiny, although many people, basically criticized and said they were effectively using, as John says here, rational basis, which is an extremely low standard for
shorthand is government wins. That's the shorthand for rational basis review. Yeah.
And, intermediate scrutiny is supposed to be a level above that, which is that the government has to identify that they're do you remember the exact?
The law is narrowly tailored for a compelling government interest.
Yeah, compelling government interest, right? And but a lot of people argued that they sort of threw out the narrowly tailored aspect of that test oftentimes, because you're talking about things like, again, total bans on categories of firearms,
or handgun rosters,
and the intention is to stop violent crime that's committed by a tiny percentage of the population, but you're banning everyone from owning this class of weapons.
Right.
Anyway, that has always been the critique, but he points out, so he says, moving to this new test, he calls it text, history, tradition, but I think really it's just text informed by the tradition during the founding era, right? That's and maybe the era of the 14th Amendment.
With a special emphasis on text, Thomas made very clear that the text was key in this. So if something implicates the text, it's presumptively lawful. Was kind of his big thing.
Unless there's an analogous regulation that fits into the tradition of gun regulation during the era where the Second Amendment and 14th Amendments were ratified. But so it's not strict scrutiny; it's below that, but it's above intermediate scrutiny for sure. And Thomas and the court would say it's a rejection of these balancing tests altogether.
Right.
But anyway, John's point here is that this new standard, the problem with it is that it seems just as subjective. And he says, creative legal minds can pour through history to make all sorts of arguments that can be used to uphold even the law struck down in Bruen. Reading some of the amicus briefs for New York, you can see such appeals. While not convincing to the conservative court, won't we just land back in the exact same situation where liberal circuit courts will rubber stamp any old gun control policy? And we wrote about this a while back when some of those briefs were being filed. We wrote about the one he's talking about, actually. And this is one of the weaknesses with this new test, is that it's still fairly subjective. Like, what exactly does it mean for a law to be analogous with something that was in place, during the founding era that fits in the tradition of gun regulation, right?
Right. And how narrowly tailored is your definition of analogous going to be? Because you could be some pretty strained definitions of analogous and say, oh, that's about the same. And so. Yeah.
And this is something we were alluding to earlier. But absolutely. I think what you'll see is that the lower courts are just going to adopt this new a new kind of language for justifying the same,
essentially the same
that they had before. And they'll say, because the court isn't saying here that you need to have an exact match for the regulation to be constitutional. So you don't need to have a ban on the sale of machine guns to civilians from 1792 for the law to be upheld as constitutional. Instead, you just need regulations on unusual and dangerous weapons. Right? They talked about that a lot. You don't need for the National Instant Criminal Background Check system to have been in place in the 18th century for that system to be presumptively constitutional, because it's designed to ensure that people who are shown to be a danger to themselves or others aren't able to buy guns, which is, again, another thing that was, broadly part of regulation at the time of the founding. They tried to keep dangerous people from owning guns. They tried to keep certain kinds of unusual or dangerous weapons from public circulation. Right. And so you're going to find a lot of ways to justify that sort of, a lot of modern laws under that reasoning. Right.
That's where our sensitive places struggle comes from, that we were just talking about with New York. Right. That's why they're testing that limit, because at the time of the founding, there were sensitive places restrictions at like polling places, for example. And New York saying, well, maybe we can stretch that analogy to cover most of Lower Manhattan or whatever, So that's kind of where this fight comes down to, is how is a judge going to read that?
Exactly. And that's exactly the thing I think people on having, very strong reactions on either side of this are missing about what's about to happen here, which is why I keep emphasizing that if the Supreme Court wants these lower courts to rule in the way that it wants, that it expects, it's going to have to step in probably a number of times before they're going to actually reach that. I mean, look at what happened in Heller, right? Heller came down and it established the Second Amendment as an individual right. How many laws were actually struck down because of that? I mean, not many. Right. Realistically. There were only a couple of handgun bans in effect in the whole country at the time. I don't know if historians can, or somebody who knows a bit more than me on this can maybe chime in the comments or something. But Chicago and DC might have been the only total bans on handguns. There might have been one or two smaller ones somewhere in other cities, but the biggest effect, and we've written about this at the Reload, of Heller and McDonald really came to stun gun bans, and that was because, and that only happened because of Sertano v. Massachusetts, which was a 2016 case that was basically just a 2-page ruling that said yes, stun guns are protected by the Second Amendment. And that led to a lot of stun gun bans getting struck down, although it took years of filing cases to do that. But so what you'll notice about that trend is the only laws that were consistently wiped from the books after Heller, McDonald, and Sertano were total handgun bans and total bans on stun guns. So now it seems to me what's most likely to happen, if the Supreme Court does nothing else at all, is that all the circuits that have been upholding these gun restrictions over the last 12 years are going to continue to do that, except for when it comes to may issue gun carry laws. Yeah. The exact specific regulation that the Supreme Court has now struck down. Yeah. So I think that's what a lot of people are missing. The only way this extends, you could be wrong. Maybe this Ninth Circuit will see the light now, and suddenly, even though there's plenty of reason to think that they could uphold a lot of these under historical precedent, or at least make the argument. I mean, like you said, that argument for why New York's law was presumptively constitutional or had this historical tradition wasn't stupid. It wasn't completely ridiculous. It wasn't necessarily ultimately convincing, but you could find laws that are somewhat analogous. I think they misrepresented some of that stuff, and that got them in trouble. But, regardless, that's the point, is like, you could still see a lot of these being upheld. It wouldn't shock me. And I think I think John's hitting on a very good point here, which is like, go look at Duke Firearms Law Center. Look at their historical database of gun laws. You're going to find a lot of stuff in there that could easily be used as like, this isn't an analog, or like, broadly speaking, these are similar ideas of regulation. And so, I think that's what the lower courts that are inclined to uphold stricter gun laws are going to now go to.
Yep. They'll just find some statutes that apply, or roughly apply. I think that's right.
What's the next question?
So this one comes from William Fuller. This is also
That's an
about,
easier name.
Yeah, I was going to say, I nailed that one. I know that. This one also deals with a recent Supreme Court decision, but not one that deals with guns. And he's wondering if it has maybe some crossover implications. So he says there have been several gun cases not taken, or taken and left to stand since the last major ruling. Does the Dobbs ruling and the votes for it have any implications for Second Amendment cases? He basically is asking, he's referring to the fact that in the Dobbs ruling, which overturned Roe v. Wade, Chief Justice John Roberts wrote a concurrence explaining his view that he would have liked to see the court uphold the Mississippi abortion law, but maybe not go so far as to overturn Roe versus Wade. Right. So he's asking, could that be a potential sticking point in future gun cases where you see justices like the Chief Justice maybe not want to go so far, while others, say Clarence Thomas or Samuel Alito, willing to be more gung-ho in the pro-gun direction? So I think that's an interesting question.
I think it's an interesting question. The main difference between Dobbs and Bruen, though, is that Roberts was joined in his concurrence in Bruen by Kavanaugh, and the whole concurrence was about how we're just re-emphasizing that the Second Amendment is limited, and that, for instance, shall issue gun carry permits are presumptively constitutional, or are literally constitutional, I guess would be the point they're making, because they're not based on an arbitrary decision by a government official as to whether or not you get your permit at the end of the permitting process. But so if you're just trying to look at like doing the numbers game, right? Yeah, in Dobbs, it was basically 5-4 for striking down Roe v. Wade, and then 6-3 for upholding the law, the actual abortion law that they were, the 15-week ban.
Right.
And Roberts' main point was that they didn't need to go further to uphold the law, as they didn't need to strike down Roe v. Wade, so they shouldn't have, I guess, was his point. But in Bruen, it's the numbers don't work out quite that way.
Right.
It was 6-3 to strike down New York's law, and then you had two justices in that majority say, but just to remind everyone, we're not striking down all permitting laws, and there are still many regulations that are presumptively constitutional under the Second Amendment.
Right.
So if you're trying to look at the numbers, Roberts and Kavanaugh could side with the liberals to block, a more aggressive interpretation of the Second Amendment in a case down the line.
Right.
I guess would be the takeaway.
Yeah.
But we don't know that for sure.
Yeah, it's just speculation, but I think that the context of him joining that concurrence does at least hint to that in the future. So I think it's
it's an interesting point though about Dobbs. Like really, that was 5-4 for the big question,
right?
And but Roberts couldn't flip another one of the conservatives to his side. So but in Bruen, I mean, look, the concurrence it's not quite the same, because the concurrence doesn't necessarily conflict with anything in the majority opinion in Bruen, right? It's not as though Bruen the majority said, we're going to strike down all permitting laws. And then Roberts said, no, we should just strike down New York's style of law. The majority opinion and the concurrence in that case were in line. It's just that I guess Roberts and Kavanaugh felt the need to emphasize the idea that they're not going beyond what the majority is saying. So it's a little different, but it is interesting to think about. It's a good question.
Yeah.
And then I had a follow-up one here about what are the conflicts and likely outcomes of the recent rulings regarding gun restrictions for citizens under 21 and the latest gun restriction bill signed into law?
Yeah. So obviously, as you pointed out, the big first major federal gun control legislation signed in several years. One of the big conflicts, you've written pretty extensively about what this bill does and doesn't do. But one of the things you're really starting to pop up is this idea of a de facto waiting period being created by the process of this background check. If you want to explain that.
Yeah, I guess there's still some dispute over this because Senator Murphy and the NRA are in agreement that it does exactly that. It creates a de facto waiting period. But Senator Cornyn, the Republican, so Murphy's the Democrat who was involved in these negotiations, and Cornyn is the Republican, and his office very much disagrees with this idea that it creates a de facto registry. If you look at the text, or not registry, but waiting period. If you look at the text, I think in practice it'll be hard to, I guess we'll have to wait and see how it works. But basically, the FBI is given 3 days to identify whether or not somebody might have a prohibiting record, a juvenile record. And then they're given 10 days total to find that record before a sale can proceed without a decision. So the text does say that they have to return an answer as soon as possible. So if they figure it out before that 3-day investigation period is over, they have to return it. So I guess in theory, it could end up being instantaneous, but it sounds like something that in practice, because the way it works is the FBI, the background check system, which is run by the FBI, of course, is supposed to call up the local police for where the 18 to 20-year-old who's affected by this regulation is living, call up their state mental health record system, and call up their state juvenile criminal record system to figure out if they have potentially some sort of disqualifying record. And so that process doesn't sound like something that's going to be instantaneous.
Just describing that process off the bat, interagency, bureaucratic, playing a game of telephone, doesn't sound like a quick thing at all. Right.
Now, I mean, I guess if these three entities all have all of their records in an electronic database that the FBI can just query, like they do with a normal instant background check. The NICS system queries a couple of databases. That's how a background check works. And so it's looking for whether or not you have a record or maybe are currently in a court proceeding, with charges, because then if you are, they might, that's when you might get delayed for 3 days. That 3-day period under the normal check, you'll get delayed so that they can look into whatever the questionable record is to see if it is something that's prohibiting. Whereas in this system kind of turns that on its head. It's basically saying like, go and look for something potentially prohibiting from these three agencies or three departments to see, rather than you get a flag that shows up in an instant check and then the FBI goes and does a more thorough, in-person look. So to me, it certainly seems like all of those 18 to 20-year-olds are just going to automatically get put into a delayed situation. And so it is a de facto waiting period, Maybe the system will work faster than it sounds like it will. Right. But that's what's at issue. But I think he's also referring to there was a ruling in California about their under 21 ban on ownership of AR-15s and other similar firearms, and so I think that could be impacted by the Bruen decision. Certainly, I think all these sort of under 21, 18 to 20-year-old regulations could be impacted, because I don't know if there's going to be an analogous historical gun regulation that targeted 18 to 20-year-olds. I doubt that that's the case.
I highly doubt it. Yeah.
Again, you'd have to go and search through and see what's out there. But I would be very surprised if those weren't implicated by this ruling. And although I will say that, like, I'm not sure that anything in the Senate bill or the new federal law is going to be immediately implicated by this ruling.
I agree.
Because what they're doing is basically, I mean, maybe this 18 to 20-year-old special background check thing could, but it seems less likely because it doesn't actually ban those people from owning guns. It just changes the background check system for them. And so you're still basically talking about background checks to ensure that they're not dangerous people, which does seem likely constitutional under how the Supreme Court has interpreted these things, or what they've written especially in Heller, about what kinds of gun laws are, presumptively constitutional. Now, that's just like a couple paragraphs in Heller, so it's not exactly completely fleshed out, but what they've talked about as categories of restrictions that are in line with that tradition, it does seem like the background check system and most stuff that involves like looking into whether or not somebody is prohibited, that those seem constitutional. And that's all this bill really does, is change those things. So
I was going to say, because they didn't go for a ban on any type of possession or purchasing, I think you're right. Mm-hmm. So,
all right, next question here. We got Buddy McDuffie with a silencer question. With silencers becoming more and more popular and legal for hunting in many locations, do you think the latest SCOTUS ruling could eventually bring changes to the NFA? And this is another good question. People I think are asking a lot. I've seen a couple people implying that basically like the NFA, the Gun Control Act, the Brady Bill are all going to be in trouble now because of Bruen. And that's another area where I just think that's probably not the case.
Right.
Because of what Heller says.
Yeah, exactly. I was going to say the dangerous and unusual weapons portion of that decision, you could very easily see a judge say, hey, look, they said that this is presumptively constitutional, that there's a tradition of prohibiting dangerous and unusual weapons. And in our opinion, those regulated under the National Firearms Act are, dangerous and unusual weapons. So,
yeah. Now, here's the only thing I would say about that to the other direction. Heller was a compromise ruling. That's what it was. Like, they needed to get Kennedy on board.
Yeah. And
so Heller was very specifically tailored to say one thing, which is that if the Second Amendment means anything at all, which they think it does, it means that you can have the most popular gun in the country in your own home for self-defense. And so DC's handgun ban was unconstitutional because of that. And so what it was trying to do is set up this baseline of what the right means, without implicating a bunch of current law. And so they wrote these two paragraphs in there. There's a couple paragraphs. It's like 2 pages in the Heller ruling that basically say, all these federal laws that exist, all these federal gun control laws, they're all fine. It talks about being able to ban M16s, fully automatic weapons, being able to, ban dangerous because they're dangerous and unusual, I guess would be the logic there. And then being able to, keep dangerous people from owning firearms. So the background check system would be part of that. Now, maybe the court will start to chip away at some of those laws down the line. It's when they get into more detail on what exactly, it means to prohibit a dangerous person. Like how, for instance, I think you could see something like nonviolent felonies, or somebody who's been convicted of a nonviolent felony being prohibited might conflict with this idea of regulating, keeping dangerous people from owning guns because,
Sure.
if you committed insider trading, does that mean you're too dangerous to own a firearm? Is that kind of the kind of person that was being prohibited during the founding era, or is that too broad? Again, dangerous and unusual weapons. That's, of course, the common use standard is very flaky in and of itself, right? Like, what the heck is common use?
Right.
Certainly for some things it's easy. AR-15s, they're the most popular rifle in the country, or even just base level Heller, right? Handguns are the most popular category of gun in the country.
Right.
And so, it's pretty easy to tell that they're in common use. Machine guns, fully automatic weapons. Well, there's several 100,000 of them that are registered in the NFA.
Right.
Is that common? I don't,
Or even silencers. There's millions registered in the NFA.
That's right. Yeah. So, I would still expect that those challenges are down the line challenges. You got a lot more things that would be immediately imperiled than the federal gun laws, honestly.
Yeah.
Maybe down the line, and but you're talking years down the line, I would think.
Yeah, I agree.
You can't know for sure, but that's where I would come down on it. All right, next question.
Got a quick one from Julio Barreto, who says, how will the ruling impact out-of-state residents? He's referring to the Bruen ruling. Impact out-of-state residents seeking permits in New York and New Jersey. So what do you think about that?
I think that was left out of the Bruen decision. Unlike Wren in D.C., where the federal court said you have to issue out-of-state permits. It told D.C. they had to do that, non-resident permits. Bruen didn't do that for New York. So my guess is none of these states are going to allow non-resident permits, and none of them are going to offer reciprocity. Yeah. So you're going to have another legal case to get to that,
right?
If you can at all. I don't know, because Bruen just didn't touch on it.
Yeah. So no, I think that's exactly right.
All right. Let's get into some ATF rules and how they're going to be affected. So Adam Nicholson asks, I'd love to know what the likely legal challenges are to the pending pistol brace rules. Or why don't we just give, I think a couple of people had asked about pistol braces, right?
Yeah.
And what's the state of them? What's going on? How might they be impacted by this ruling? And well, first off, just the state of them. It seems, so the ATF in a legal filing in a Second Amendment Foundation case said that they have finished reviewing 200,000 plus comments on the pistol brace ban rule. And I think they're formulating their final rule now, but they're expecting it to drop in December, the final rule. It wouldn't go into enforcement until sometime next year. Most likely is usually there's like 90 to 120 days before these things go into, are enforced. But, similar to the ghost gun rule, which is still not enforced yet, right, even though the final ruling has been made public. But, so that's actually a delay, because it was everything that we had heard was August. And so now it's December. Of course, the ATF is kind of in flux right now, because they just demoted the acting director at the request of basically the gun control groups who didn't like him. And they have another acting director who's also a U.S. attorney in Arizona. So he's they kind of have like a part-time acting director right now. And of course, Biden's permanent director is he's still waiting for his full vote in the Senate, although it seems very likely that he will be confirmed at this point, because the vote to move him from the judiciary, the vote in the Judiciary Committee was a tie. So all the Republicans opposed him and all the Democrats voted for him. But the vote to discharge him to a full floor vote was, I think it was like 52 in favor. So it's extremely likely he will get at least 50, if not, 51 or 52.
Yeah.
But that hasn't happened yet. And I think that a couple of senators have had severe injuries
Yeah.
Didn't Kramer like cut his hand off
Yeah.
or had something close to that?
He had a catastrophic
And then-
lawn accident or something like that.
Yeah, something crazy. Although I think he's going to be back relatively soon. But was it Leahy?
Yeah,
Fell
from
and broke his
Vermont. Yeah.
hip?
Mm-hmm.
Yeah, because all these people in the Senate are like 99 years old. So
Yeah.
literally a senator broke his hip by falling. So I think that might actually have some impact. I saw a Washington Post reporter was saying, I can't remember, I think it was Du Bois. And he's a top Hill reporter. So he said that might slow the timeline down. I don't know. We'll see. But anyway, the brace rules, it seems like they've been pushed back. Won't go into effect until at least next year. So, and then as far as like, I think these next two questions are similar to, are all going to be the same basic question, which is,
Right.
We got JB Sumner and Ben Leonard, and they're asking about the ruling in West Virginia versus EPA, right? And how that has an effect on the ATF's ability to promulgate these sort of regulations,
Right.
and how that might affect, the brace situation. So, why don't you tell us a little bit about what happened in the EPA?
Sure. Yeah. So the whole deal in the EPA case was essentially the Environmental Protection Agency under Obama. So this dates back to an Obama era regulation, very broadly construed an obscure portion of the Clean Air Act in order to promulgate rules that created a de facto cap and trade program and, blah, 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 blah. I won't get into many environmental details for this podcast,
Right.
but essentially what the court said was, hey, you can't do that without explicit authorization from Congress because this rule would have substantial economic and political implications. And when that happens, it's what's called the major questions doctrine. Expect the court to take a closer look at what your statutory basis is for doing these regulations. And they said,
And
hey,
do you think that
you don't have it here.
Yeah. Do you think do you think this sort of pistol brace regulation rises to that major questions standard?
I could see an argument for it because, as we've written in our reporting, there are millions of these pistol braces out there. A lot of gun owners own them. So you could make the argument that, hey, this is going to have severe economic and political implications because you're criminally prohibiting something that millions of people legally own. At the same time, the statutory basis for their actions are a little more firm than it was in the EPA's case, like the NFA.
Right.
There are explicit definitions of what a short-barreled rifle is as it pertains to the NFA. And if the ATF is just saying that we're going to interpret braced pistols with the barrel length that fits the same as short-barreled rifles, I think that's an entirely different calculus here than what was at issue in the EPA case.
Right, because I think one of the key things in the EPA case was that the cap and trade proposal that the EPA sort of unilaterally put in place themselves using this vague statute, that proposal was debated and rejected by Congress a bunch of times. Like that was
Right.
like one of the main environmental policies that Congress has been fighting over for years. And so the fact that they never actually passed it and then the EPA came along and basically did it on their own without really statutory authorization, that's a little different than the ATF changing its view on what constitutes, what fits this definition of, short barrel rifle.
Right.
Although obviously there's probably a case to be made that you could see it being challenged under that, I think, and under Bruen.
Yeah.
Although if you challenging it under Bruen, you'd have to challenge the whole NFA, which again goes back to this question of whether the Supreme Court would go for that, because they've been pretty, at least ancillary comments, they've been pretty comfortable with saying the NFA and other federal gun laws are constitutional to this point.
Right.
But so maybe the EPA thing might even be a better challenge than
Could be.
going the Bruen.
I would say definitely expect people to try in litigation. I would just say have cautious optimism if you think that's going to be the winning ticket for dismantling the regulation, would be my final take.
And then Let's do real quick. We have Kazam. Basum is not his full name, but he asks. It's a member that asks, please describe the exact new rules surrounding ghost guns. I've heard so much bad information. I don't know what to believe. I would love to hear what this new regulation includes and doesn't include. So what we have a piece on the Reload that gets into more detail on exactly what the ghost gun rule change does. But effectively, it really goes after ghost gun kits. And so essentially, you cannot sell. They're interpreting a ghost gun kit as an actual firearm. Yeah. So if you have the 80% lower, and you have the jig and the tools to complete the 80%, and you sell that all together, or you put it all together in a kit, then it becomes a firearm. And it's subject to all the regulations of selling a firearm. So basically, like Polymer 80 or somebody, they can't sell you a kit anymore. But it doesn't make ghost guns illegal. It doesn't make it illegal for a person to possess an unserialized firearm. Now, there are state laws that are going that route. And that's another thing that actually is probably going to be implicated by Bruen, frankly. Because I don't know that there's any historical analogy for that sort of regulation that's, saying that you can't.
In fact, it'd be quite the contrary, I think, since self-manufacturing of firearms is so, old as a tradition.
Right. So. And it was probably the main way people got guns in the founding era. So, but yeah, now effectively it doesn't like if you have ghost guns now, if you have unserialized firearms that you've previously built, as long as your state doesn't ban them in some way or place further regulations, the new rule doesn't impact you. It impacts perhaps what you can buy. Because you can't go out and buy the buy, build, shoot kits anymore. Although they were already coming under heavy scrutiny anyway. Yeah.
Local jurisdictions were always
ATF,
suing them. And
but that's mainly what it does is it goes after kits. It sort of uses this new very broad definition of firearm, which that might have some EPA, that the EPA case might come more into play there because of what the ATF is claiming as its authority for defining what a firearm is, even though they're saying now that they're not necessarily going to practically change how they've done things the last 50 years. The authority they've given themselves is extremely broad. Right. I think we have time for just one or two more questions here, but we got another one from Kazam. Kazam. It's like Shazam, but with a K. Or Kazaa. Remember? Are you old enough to remember what Kazaa was?
I don't know Kazaa.
It's a P2P sharing, file sharing thing, like LimeWire or Napster in the early days. Anyway, that's the one I used in college, so people might be able to guess my age from that. But what are the real changes to who does and does not need a license to sell guns under the new federal law? I read the change and I'm not sure I can see the difference between the old one and the new one. I don't have an FFL and don't want to get one. So being clear on what's this change in the law is about would be great. This is another really good question. And one I think that's been super undercovered and hasn't really gotten enough attention. I think the industry doesn't really, this is something that you might think they'd get involved with, but it really doesn't impact them much. Right. People it impacts are private citizens who sell firearms. Because the change, you're right, there isn't a huge difference between the old definition and the new one, but there is a difference, and I think it is a significant one. Both definitions are extremely vague, right? So the way we regulate firearms in the United States is we regulate commercial sales, like a lot of things, right? If you want to have a business selling guns, then you have to get licensed by the federal government. And along with that licensing requirement comes the requirement to do background checks on people you sell guns to. So this has been a contentious issue for years because, the gun control advocates and Democrats want more background checks, more sales to be covered by background checks. So in theory, most of the time they want more. You would think that would mean they'd want more people to be FFLs. And that's kind of what this new rule change or regulation change is aiming at. But for a long time, they didn't. It was actually the opposite. The Clinton administration didn't like so many people having FFLs in the 90s. Because there was an issue with what's called kitchen table dealers, where there were a lot of people had FFLs, way more than today. Hundreds and hundreds of thousands of people had FFLs, and they wanted to crack down on that, so they modified the definitions and up the fees to get an FFL in order to get rid of a lot of these kitchen table dealers, people working, operating in a firearms business outside of their house. And in a lot of cases, really not doing much in the terms of the business side. When you have an FFL, there are other things that are beneficial about that. Like you can have guns shipped directly to your house if you have an FFL.
Right.
Right. So you don't have to go through the background check when you're buying a gun. That sort of thing. So there's advantages, and that's why people would get them. But and you can occasionally sell guns for profit too. You can get guns from the manufacturer and sell them. But anyway, this new change, the thing that's significant about it, the thing that says, so you need a license if you are in the business of dealing firearms, right? But now, what does in the business mean? Well, it used to involve, a standard for livelihood and profit. So you have to, derive some of your livelihood from selling guns. You have to make a profit. Now they've removed the livelihood standard, and it's just about profit. So it's still unclear. The thought was before this went through that they might put a number, like how many guns you could sell before you had to get a license. But they didn't do that. Instead, they just slightly tweaked the language and got rid of the livelihood aspect and said it was just, if the main purpose is profit, then you have to get a license. And it's not clear what that means. It's even less clear than before, because before at least you had, I think Charles Cook mentioned this in the podcast last week, at least you had, several decades of case law to figure out what that means. Now they're kind of resetting the whole thing, and it seems like a lower standard, frankly, one where if you sell even a single gun for a profit, in theory, maybe you would have to get a license to do that. It's
really
strange. Still very murky.
It kind of tries to bridge the gap maybe between the Clinton era crackdown and also still allowing people to get FFLs so they do conduct background checks when they sell guns. So like you said, it's a weird murky gray area that they landed on with that definition.
I think it puts a lot of people in legal jeopardy who otherwise wouldn't have been. That's what I would say. And it still basically leaves it up to the ATF to determine on a case-by-case basis who they think needs a license.
No,
so,
exactly.
I don't know if that doesn't sound like a good outcome to me. I don't know why anyone would root for that. I mean, it's just, it's sort of like, just giving the ATF more leeway to determine things however they want.
Right.
And a much more aggressive standard. So I sold a gun for profit once. When the prices were through the roof, I sold one of my ARs and made money off of that. I sold it through an FFL. I don't know. So, it makes it very unclear to me. It makes it more unclear than it was before.
No, I think
even though the standards are fairly similar. And then let's do one last question here just to wrap it up.
Okay.
We have Julio Barreto, who asked what are good resources to share with those seeking firearm ownership for the first time. And this is our last question, but I think that there's a lot of great resources online now. YouTube has really good resources for first timers, gun reviews, things like that. Active Self-Protection, which, I do their podcast every week, which is a good podcast you guys should check out, especially if you've made it this far into the episode. it's probably something you'd be very interested in, because they analyze real world shooting incidents and self-defense encounters. So I've always really valued the work that they do. Then their YouTube videos are fantastic. Their podcast is also amazing because they actually interview some of the people in those encounters. You can learn quite a lot about the real life incidents, how this stuff actually happens in the real world. But your NRA basic pistol courses are great. I'm certified to teach that. Those are available nationwide. Whatever you think about the NRA and its current struggles and dilemma, it is still by far the largest gun training association in the world, really, and they are readily available, those classes, everywhere. And so you also have groups like USCCA that have certified trainers as well. And I would suggest finding a club that matches your interests, what you want to do with shooting. There's also really good clubs for people with shared backgrounds. The National African American Gun Association, a Girl and a Gun shooting league, the Liberal Gun Club. There's all kinds of groups out there of people who are like-minded or have a shared experience or shared background that can be helpful to new shooters to understand that they're not the only ones, right, with that background or worldview that enjoy firearms. Of course, it's not necessary to do something like that, but I find that people say that can be helpful. Yeah. If they're in those communities, but there's also just all kinds of shooting clubs out there, just regular shooting clubs that you can join. Head to your local range, take a class. Most of them will offer gun safety training, and a lot of them will have rentals for guns, and definitely take some training before you start shooting. Yes. Certainly, or go with an experienced shooter who can show you what to do. But yeah, you can look up things online and then head to the range and try them out in real life. And see what you enjoy. You can try all kinds of there's all sorts of different shooting too. Is another thing that's important to understand. Like, even if you don't enjoy shooting paper with a handgun at the range, at an indoor range, like maybe try skeet shooting at an outdoor range somewhere. That's a very different experience.
Yeah. I would just echo everything you said. When I became a first-time gun owner just a few years ago, so this is pretty recent for me. But I was fortunate to at least grow up with a household that was familiar with guns, but guns weren't a huge part of our lives. So when I turned 21 and I could legally go buy a handgun and I was interested in it, people online were an indispensable asset for me for figuring out what to look for in a first-time gun, what would be some good options. And from there, like you said, I went to my local gun range. I took some training courses just to brush up on my skills, and it made the world a difference. And so I would just echo everything that you just said, that definitely seek training, and then don't be afraid to use all the resources at your disposal to explore all that shooting sports and firearms ownership has to offer.
Absolutely. And of course, you can sign up for a Reload membership.
That's too, right.
And talk to us or ask a question on this podcast in the future. Or come on the podcast yourself. We're hoping to get another members segment going again soon. Always enjoy doing those. So head over to the Reload and see what our membership options are and if they fit with what you're looking for. Or, sign up for the free newsletter. Give it a try. See what we've got to offer before you buy any memberships. Or, you could just stay on the free membership. You'll still get all of the biggest stories that we break. You won't have access to some of the exclusive stuff, but you'll still, I think, get a big benefit out of it. So check it out today over at reload.com. That's it for us. We will see you again next week.